Now, maybe you could give us a rough overview of the issues related to EOS governance at this moment. There has been a lot of emphasis being placed on the ECAF process. Maybe you could shed some light.
Yeah, I think the biggest single challenge that we currently face relating to governance is the fact that we are in this this interim state without a ratified either a ratified constitution or as a consequence a ratified arbitration service. So where we are right now, for example, is that you look at ECAF and what it is. It's able to pass advice. It's not able to pass official orders that in any capacity. And because the Constitution itself has not been ratified underlying that, we are left in a situation where if they pass advisory orders, block producers are being left to pass and make decisions between themselves as the only real elected representatives on this network so far to actually enact them or not. And that is what's caused so much of the early controversy between those decisions to freeze accounts. So to my mind, the single biggest challenge for the community as a whole, all of us, is that we need to actually vote on a referendum and actually pass a constitution, whatever it may be, because that will add a lot more clarity around the boundaries of responsibilities for both block producers and the likes of ECAF in terms of where it fits in.
Great, thanks, David.
Okay, so Kevin, so can you share with us, since David shared that you guys decided to go ahead without consulting ECAF, so can you share about what's your opinion on that?
Are you talking about when the unanimous decision was made to blacklist a number of accounts?
Yes.
Okay. First, we absolutely did consult ECAF. So a few days prior to that happening, we were all of the elected block producers were on a call with Moti, the head of ECAF, where we described to him the situation where accounts were in danger of imminent theft. Tokens were going to be stolen. And what we were asking him specifically, and it was me, I actually made this request. And I was very careful with my words. I didn't want to say, we need you to issue an order that asks us to freeze these accounts. What we said on the call was, we are going to submit a claim to you that has to do, we're not even going to discuss the content of, but we would like that you expedite the review of this claim. That is all we asked on the call. And days went by. In the claim that we sent, days went by where we didn't receive a response. And then finally the day came where these tokens were going to be unstaked and they were going to be stolen. Their response was, I'm sorry, we do not believe that we possess the authority to provide you an opinion. And so we were left with the choice of allowing property to be stolen or following the process to the letter. And the difficult thing was the process to the letter, so to speak, it was sort of non-existent to begin with. We didn't really have a process in place. So this whole time, we're all trying to follow the spirit of this governance system that we had been working on for so many months. But just to go back to your original question, we absolutely did consult ECAF prior to making this decision. And I mean, consulting is a weak word to describe it. We pleaded with them to provide a ruling. And actually, I want to ask David a question. So I'm very excited to hear more about Moti and what he presented tonight. But that when you said that the arbitration opinions or advice, is that only describing their rulings, opinions, whatever, in the context of the constitutional gray period we are in, or given proper constitutional authority and process and setup, do they still consider themselves only providing an optional opinion to follow?
Yeah, they didn't actually clarify that question when it was put to them. Not sufficiently, to my view, whether or not this is just for this interim grey period or whether we should always, as block producers, have an opinion on this. What I'm taking away so far, and seems to be the emerging consensus on that, however, is that we always, as block producers, should form our own opinion and, in theory, veto a decision rather than necessarily being a jury within this and making other decisions. But if there is something fundamental that ECAF were to pass as advice stroke an order, and we did not agree with it, we are entitled within our power to actually veto a particular decision. And obviously it would pass in theory on a 15+1 majority.
So that's what Moti said?
No, but this is what he sort of hinted at in his reply. It was quite a grey response to a grey question in that sense. Still, to me, though, the uncertainty around this is it puts block producers in a very challenging position because we don't really yet have full clarity on answers to a question like that. And to my mind, we really should be given as much guidance as possible, because what we have, for example, in our own code of conduct, EOS42, and this was circulated as part of the community, most of the block producers I'm aware of published out a code of conduct, circulated it to the community, it was debated, and then it was implemented as part of their whole election pledge. And ours is that we would execute all arbitration orders, and that it was not for us necessary to question them. And at the time, that seemed to be the consensus amongst the community. And since then, it's become more of a challenge from the likes of Daniel Larimer and others that actually block producers should not be blind robots that implement, but we should also have that power of veto and exercise it where they feel is applicable.
So, David, we took your. It was great when you issued that code of conduct, and we followed by issuing our own as well. I think it actually, to hear that, or to hear that he hinted at that, it makes me very disappointed, because what we need to do as a community, and this is not up to the block producers, this is up to you, the token holders, and to everybody out there. We need to decide if we would like binding dispute resolution in EOS, because if you have a deciding body issue an opinion or ruling or order or whatever you want to call it, and the group that is responsible for executing that order, if they have the ability to evaluate it, to decide whether or not they want to do it, we don't have binding dispute resolution. And I'm not advocating one way or the other, but we just need to make a choice, because it's not this gray thing. Either arbitration is binding or it isn't. That's it. So we can make that choice when we have the ability to vote on referendum. So
maybe we cross over to Eliot. Eliot, what do you think about the current debacle? It seems to me there is very much...
from my... frankly speaking, we are... this is just an objective idea, and we just respect each VP's and ECAF's action. First of all, the stolen token or any unfair transaction should be freezed. That is very necessary, we think, to protect the personal the asset. That is definitely necessary. The second one is between the ECAF and each BP, we need more very smooth communication. This time, this was the first case. That's why we had some difficulty or the different opinion. It was not easy. This case, we can have a very smooth communication method or tool. This case, it will be a good lesson for all of our players, I think.
How about Denny?
I think, there's two alternatives today. The first one is ECAF just issue the opinion and let the community choose for it or not. That's good, because ECAF don't need any power source or to just can leave opinion, just like what a consult firm do in K Street in Washington, and they tell the Congress you might want to do that, and the Congress do it as well. That's great. And at SPP, we are just congressmen. And in other words, is hey, the ECAF is Supreme Court, so we must put every arbitrator to pass the the referendum. The power comes from the token holders. So we have two solutions for the governance things. That means we have two ways to follow. That's what I think.
I disagree that the power comes from the token holders. It does, ultimately, but the power comes from the Constitution, and the Constitution is voted on by the token holders. And I think that we're trying to take these ideas of a Supreme Court or consultants. The arbitration is a real thing. It actually exists. It's out there. It's working in dozens and dozens of countries. I feel like we're not looking out to them to understand how it already works in the real world. And in the places where it works, it's not an opinion. And again, I'm not advocating that we have arbitration or how we have it, but what I'm trying to convey is that it is binding if we are going to have it. If it's not going to be binding, it's literally worthless. No one needs to listen to opinions. We have more to do. And also the difference between them being like a consultant or, you know, they're resolving a dispute by two consenting parties, or at least one consenting party in the case of a frozen account. But we just got to start to work through arbitration as a concept. Forget ECAF for a little bit. Just what is arbitration? Do we want binding dispute resolution on chain?
David, do you agree with what Kevin has said?
Yeah, I mean, I think fundamentally, Kevin's completely right. It is about us actually making now some underlying fundamental decisions as a community about how we want the role of arbitration to fit. And this actually also comes down to the differing views of either the interim constitution, where you have arbitration at this base level, or whether or not you apply it at a DAP level on this secondary layer above, and where you could have multiple competing and differing types of arbitration and governance systems within each individual application. We need to make some of these fundamental decisions before we're really able to answer and have a lot more clarity in terms of how we want block producers to behave within this. Yeah, I think if you look at it in the real world, arbitration is not an optional thing that people implement. They are binding decisions, and that is the whole purpose of them. That provides the clarity by which you get independent decision-making for dispute resolution. And where we have a situation right now where we're being told that, in theory, that is not the case, it is a challenge, I think, therefore, for block producers to be absolutely sure, therefore, on what their conduct should be in these scenarios right now. It also, I had a discussion last night with some people at the event, and I did make the point that where you have block producers, in theory, also looking at difficult decisions. Sometimes decisions are not always popular, but they can be the right decision for the community long term. You could end up whereby block producers being so accountable to token holders on an ongoing basis may opt to veto a decision rather than approve it, simply because it's a very unpopular one, even though it's the right decision. And there you have an immediate, to me, evidence of a potential conflict of interest there as to being whether or not they are the impartial and right ones to be making a judgment call like that. These are the sorts of challenges that we need to work through as a community and make a decision about.